Good afternoon, everybody. I'm very happy to be here today. I am Mitchell Somm. I'm the sales director at BDV Solutions. And today I am joined by Charlie Oppenheim, who is a former State Department official. Charlie's going to talk a little bit more about himself here in a little bit. And then Chris Richardson's down here below me. Chris is the COO at BDV Solutions. Chris will also do a little intro of himself as well before we get started. But I wanted to welcome y'all today. We actually had over 300 people RSVP to this online event in our Facebook group. So thank you guys for taking the time out of your day to watch us. I think someone said that there's no audio, so can you guys hear us? If you could just comment and let us know that you can hear everything, that would be great. Probably get a bunch of comments rolling in here in a second, but so I hope people can hear us. Okay, yes, people can hear us. That's great. Cool. So I'm really excited today to have Charlie here. Charlie's going to be talking to us about his experience with the U.S. State Department. And I think Charlie specifically worked with the visa bulletin, which is a big topic of conversation here within the EB3 unskilled community. So before I get started and let them introduce themselves, I just want to say that this is something that's pretty unique. There aren't a lot of other agencies and other companies, I think, out there that are making this effort that BDV does to really understand and learn more about the government and their processes and how they go about doing things. Because I think oftentimes it can be just really confusing for everybody, just in terms of immigration processing times and visa retrogressions and stuff like that. So I think Charlie's going to be able to give us a little bit more clarity today into some of that. But without further ado, I would like to introduce Charlie.
Hi, just give you a real quick brief background. I worked at the U.S. Department of State for over 43 years. I was Chief of Immigrant Visa Control and Reporting Division for over 23 years. During that time, I coordinated with the USCIS and our overseas posts with the State Department in an attempt to maximize number use each year under the various annual limits. The decisions I made while I was chief allowed over 9 million applicants to get issued an immigrant visa or adjust status. I worked extensively with the White House, in congressional offices, in immigration reform efforts, answering their questions and commenting on visa bills. I testified before Congress on 2 occasions as the representative for the State Department. And that's it in a quick nutshell. Oh, and with the visa bulletin, I was responsible for publishing that on a monthly basis, making the determination of both the final action dates and application dates, which were listed in it. And my efforts, I always try to use the visa bulletin to relay information that I thought was important to the immigrant community, and give at least 1 to 2 months advance notice if I thought something that potentially could negatively impact them was potentially going to happen. So that's in a nutshell.
Great. Thank you, Charlie. Appreciate that. Seems like you have a lot of experience within the State Department. So just curious here, did you do any of the specific individual visa interviews kind of like Chris did, or did you start as a officer and then kind of grow within the State Department?
No, I was always civil service, so I never served overseas for any length of time. I did run for about 5 weeks. I ran the non-immigrant visa section in Vancouver back in the 80s, made several trips overseas for conferences, and traveled extensively throughout the U.S. speaking to NGO groups at various congressional conferences and conferences that USCIS was holding.
So Charlie is being very, very modest. I think I was talking to a White House official, and they said that Charlie Oppenheim is the most feared and loved person in the entire immigration space and system, because he has so much power over immigration and visas. And so, could you talk a little bit about why would the White House say that, right? Like, why would USCIS say that? Oh my God, this guy is so powerful in terms of visa bulletin and visa retrogression and how you worked in that space specifically.
Sure. Often either the White House or congressional offices who are interested in doing some type of immigration reform, if they had come up with language for a potential bill, they would run it by me. They would send me an advance copy, which I and other, often the lawyers in the Bureau of Consular Affairs could take a look at. And I would comment on it in terms of what the impact of their proposed changes would be on the availability of visa numbers, how it would impact consular processing and processing in the U.S. with the Immigration Service. They would also ask me, I could not, unless they asked me, I couldn't make suggestions on bills, but I could comment on, to try to clean up their bills and say, well, if your intent is this, because they would tell me what their intent was. And I said, the language you're using or the way you're going about it will address what you want to do and let it and have it work. Or I would tell them it's not going to work the way you plan it. And then they could tweak their bill. And then they would send me another draft and I could comment on that regard. Often back in 2012, late 12 and in 2013, there was a lot of immigration reform. They were trying to do it, make drastic changes to the primarily the employment categories, but there would have been some changes to the family categories as well. And again, I would tell them what the impact was going to be and if it was going to work. But sometimes they would come to me and say, well, we would like to do something, but we're not quite sure how to go about doing it. And then I was free to offer them suggestions, how that they could accomplish their goal and proceed. And it was always felt kind of honored and happy to be able to meet with the White House officials and congressional staffers to try to accomplish their goals. Unfortunately, there hasn't really been any major changes in immigration since the Immigration Act of 1990. That was the last pretty much major changes. There's been some slight tweaks to it, the Immigration Nationality Act, but nothing major has occurred at that time.
Now, so we're here in the EB3 unskilled space, and we are now going through visa retrogression. What did every month, the numbers come out. What went into those numbers? When did you decide, okay, I'm going to put visa retrogression in place? Why would you put visa retrogression in place? And specifically for EB3 unskilled, what are some of the reasons why we might be undergoing this visa retrogression right now?
Yeah, let me just give you a little background on the numerical control process. There is an annual limit, overall employment limit, and then each of the preference categories, such as employment third preference and the other worker category, received a percentage of the overall employment limit. And then there was also per country limitations, which I needed to take into consideration. And I basically tried to maximize number use through the movement of the final action dates each month in order to try to get as close to the annual limits as possible. One way you could kind of compare this to your personal life is if your employer gave you your check for the entire year on October 1st, so that you got your check for the next 12 months. and what you did is you looked at your normal household budget. You had to spend a certain amount on housing, insurance, expenses. You wanted to save for vacation or whatever you were doing, and you established your household budget, and then you would and your goal was to try to use all of the money in your paycheck, because you knew at the end of the year on September 30th, if you had any money left over, you had to give it back to your employer. But at the same time, you could not spend more money than you had received on October 1st. So that was the maximum you had. So you would reevaluate your budget issue on a monthly basis. And if you had, if your budget was, you had more money left under your budget, then you could do more things the next month. If you had less money available, then you might not be able to do as much the following month. So again, I would try to move the final action dates. I typically tried to maximize number use during the first 9 months of the fiscal year. And the reason for that is during the summer months, overseas posts have a lot of transfer of foreign service staff. So, and they also face a heavier non-immigrant visa workload during the summer months. So I didn't want our overseas posts to have a lot of workload on the numerically controlled categories during the summer months when they may not have staff to address it. With the same thing in the immigration service, I wanted to move the dates early in the year, knowing that it may take from the time somebody were to go into the USCIS office and file for adjustment of status, it would take many, many months for that case to get processed. So I wanted to have time for those cases to be processed. And I didn't want to go into the end of the year in the, say, July, August, September timeframe, where there would be a lot of extra numbers available, but we didn't have time to use them. So again, I wanted to make sure that I moved things early and allowed applicants to get their cases in the processing stage as early as possible.
Now, we have visa retrogression going on right now with EB3 unskilled. And there's been visa retrogressions in the past. How have those visa retrogressions been resolved in the past? How did they get back to current? What are some things that BDV could do or the government can do to get visa retrogression over with EB3 unskilled?
Right. What I typically did is, again, you had your annual limit, and I would try to ease into it at the end of the year. And if you started running out of numbers and you were coming up against the annual limit, what you had to do, you had two choices. Either you could retrogress the final action date in order to try to limit future number use, and or you could let it go until, say, sometime in September and then make the category unavailable. But typically, if I had a retrogression, I would try to hold off as long as possible and only do it in the August or September timeframe, because I knew that you may have a case that's in various stages of processing, and for the category to retrogress sometime suddenly in August or September, then that applicant is on hold until October. So I would try to minimize the disruption in the client's status. And I would also try to typically, if I did have a retrogression, I would do everything possible to try to completely recover from that retrogression in October when I had a new full supply of visa numbers. Sometimes that was not possible, but in most cases, I was able to have a recovery. The one problem that they are now facing with 2023 is the employment limit I'm estimating that it's going to be at least 80,000 fewer numbers available under the fiscal 2023 limit as opposed to what was available in 2022. That is going to impact, the availability of numbers. And I think it's part of the problem with the employment third other worker category. They were trying to maximize number use last year, and then they ran out. They processed as many cases as they could, and then they ran out of numbers. And now, based on the other worker category having been current for so long, as was the third preference, they now have a supply of cases that are ready to go, but the amounts are exceeding the amount of numbers they can make available on a monthly basis. And that's why they retrogressed the date. And the final action date is always the date, the priority date of the first applicant who could not be accommodated for a visa interview or adjustment of status in that particular month.
So what you're saying is that there's a backlog of older cases that we really need to work on processing through, and then maybe then we can get back to current. And I think in 2005 or 2004 there was a similar issue where there was a larger backlog of past cases, and once they got through that backlog, they were able to get back to current.
Exactly, and it's very possible. You know, like I said, the Immigration Service, their top priority for the past fiscal year for 2022 and for 2021 was an attempt to maximize number use under the extremely high limits. Again, the 2022 annual limit was approximately 281,000. That was the all-time high. And so they were trying to, doing everything possible to get cases ready to use numbers. And so they may have got a lot of the employment of other worker cases ready to go, but they couldn't be processed at the end of the year. So they have a big pool of applicants that are ready to go, but that pool exceeds the amount of numbers they have available to use.
And I think the good thing here is that both the State Department and USCIS are really focusing on issuing those old cases so that they could potentially get back to being current with EB3 unskilled.
Right. And with the date having retrogressed, it's about 2 years behind roughly now with the third preference, other worker third preference date. I think that what is encouraging is they have an application filing date for the employment third preference other workers of September of 2022. That means that the State Department, in coordination with USCIS, believes that by the end of this fiscal year, they will at least get to September of 2022 on the processing of other worker cases. So that is a positive sign. And again, if you look at chart 3, those are the application filing dates, and the State Department uses those dates to notify applicants who are overseas to begin assembling certain required documents, because that is the date that the state believes will be the final action date 8 to 12 months in the future. So we wanted to start getting the cases ready in advance, so when the date had moved forward, they could be scheduled for interview. The USCIS, since October of 2015, has also been using those dates to allow people to file early for adjustment of status. Based on their determination, Chart B can be used. And again, that will allow the applicants to be ready. USCIS can have them ready and ginned up and report them to the State Department so that State Department can use that information in the determination of movement of in this case, the other worker category.
Okay. And do you think that in the past, has the State Department made this kind of huge effort to issue a bunch of old cases to get back to current? Have you seen that happen in the past?
I think they will. And one other potential reason for the retrogression is because of COVID. Starting in March of 2020, most of the overseas posts were shut down for normal visa processing, and that stayed that way and probably until the remainder of fiscal 2020, much of 2021, and it really wasn't until fiscal 2022 that posts started opening up on a more larger basis. So the State Department is having to pretty much have a catch-up process. Cases that would have been normally processed during the previous 12 to 18 months, they suddenly had to do those. So they may have had a lot of employment third preference other worker applicants who were eligible to be processed, a year ago or a year and a half, and they had to be processed. So that would also put a strain on the limitation, the annual limit for other worker cases, and be one reason that they retrogressed the date. And it's important when, in my years of determining the dates, if I was going to do a retrogression, my attempt was to do it only one time, because I knew that it was going to cause problems and it was going to cause a lot of concern with the immigrant community. So I would try to do it kind of in a worst case scenario so that I could kind of draw the line in the sand, as they've done now with the June 1st of 2020 employment other worker date. Then I could slowly move and start to advance the date. But I didn't want to be in a position where, say, this June of 2020 date for November, and then in December they move it back to January of 2020 or something. I wanted to have it a one-time retrogression and then hopefully be able to move forward from that point.
Okay. And so as the embassies open back up and as USCIS issues more visas, you suspect that they're going to catch up based on what that chart B is saying, that they're going to eventually be able to catch up and get back to current?
Whether they can get back to current, I'm not sure. Again, that September 8th of 2022 is where they think that the date will be roughly 8 to 12 months from now. So whether employment other worker category can get back to current this fiscal year, I would not speculate on that at this point, but I would say that the fact that they have established that date should be reached no later than September of 2023. And it is what is important to the listeners is to look at the chart B and see if there's any movement in that other worker date. If there is, that will kind of give you an early idea of the fact that they think that they're going to be able to use more numbers and move the date later in the year. Okay. So it's kind of a combination. Look at the chart A, see if the employment third preference other worker category date is advancing, and also look at the chart B and see how that is advancing. Again, knowing that that chart B date is where the final action date listed in chart A is likely to be 8 to 12 months from that point. Mm-hmm.
Now, BDV is working with you and several U.S. senators to potentially, recapture old visa numbers. We've also talked about maybe exempting dependents. That would be very helpful. What do you think would be some of the more helpful things that Congress or the White House could do that we're already working on, but like maybe some extra things that they could potentially do to lessen the chances of visa retrogression in the future?
Well, one of the things that would have been beneficial, particularly in the past 2 years, would be an adjustment to the language affecting third preference other workers. The current Immigration and Nationality Act language says that the employment third preference other worker applicant or category can use up to 10,000 numbers. So it says up to 10,000 numbers available. That limits it. Whereas the other categories, the third preference as a whole and the employment first, second, and third, they get a percentage of the overall limit. So with this past year's limit, the third preference was entitled to somewhere in about 75,000 numbers in fiscal 2022. that would have been an extremely high amount, but the third preference other worker category was limited to up to 10,000. If it had said 25% of the third preference, overall third preference limit, they would have been eligible to receive up to approximately 20,000 numbers. And again, the normal, and the reason I mentioned the 25%, the normal minimum third preference limit is 40,000 numbers. And again, the third preference other workers is entitled up to 10,000 of those, or roughly 25%. And that's why I say, if the congressional offices were to entertain a change in the language, instead of saying up to 10,000, say up to 25%. It would be the same as they have the current language. It would just make an adjustment and attach a percentage. And again, if that had been in existence in fiscal 2022, the third preference other worker category would have been entitled to approximately twice as many numbers as they were able to receive under the current INA. And that's kind of confusing, and I may have confused everybody. But again, it's a slight change. Change the current language for third preference other workers from saying up to 10,000 and change it to say up to 25% of the third preference limit.
Yeah, and that's something we're definitely working on with a couple of U.S. senators to hopefully get that language included in some bills. What about this idea of exempting dependents? Do you think that would help as well?
It would. Exempting dependents is something that's been advocated for years and years, probably well over a decade. It has not gained any positive traction. It's been spoken of a lot in various immigration reform efforts. It's never gotten close to passing. If you remove dependents, it basically potentially triples, quadruples the amount of applicants who are eligible, because it's important to remember that each applicant in a case uses a visa number under the annual limit. So if you have the principal applicant as a third preference other worker, they apply and they have a spouse and 2 children, that's going to use 4 numbers under the potential 10,000 limit. If you take that away, you'd only have the principal using 1 number. The spouse and 2 children would not use a number. So that would be a very beneficial, and this would be beneficial across all visa categories, where, because all numerically controlled categories where the dependents are charged against the annual limit. But congressional offices and people that have looked at that say, well, you're doing the same thing as if you would just increase the annual limits, and typically they're against increasing the current annual limits.
And that seems crazy to me, because we've had the same limits for 30 going on 40 years now, and the country is it's far bigger than what it was in 1990. And so it just seems nuts to me that we're doing it this way. Mitchell, do you have any questions or any questions from the Facebook folks?
Yeah, definitely.
Can I make one comment on that? Again, Chris, you're exactly right. The Immigration Act of 1990, when they changed it, prior to that, the employment annual limit was approximately 54,000 numbers. With the Immigration Act of 1990, they changed it. They upped it to 140,000 for the employment categories, made many more employment categories. So it was a huge increase. And they felt at the time that was more than enough to address the, employment situation. But they haven't done anything since 1990, which that Immigration Act of 1990 took effect for fiscal 1992. So you're absolutely right. It's been basically stagnant with no substantive changes to the annual limits since that point.
Interesting. Yeah, I have a couple of questions that I would like to ask Charlie. The first one is going to be, we have a lot of clients that are concentrated from certain nationalities. Brazil, Bangladesh, and Nepal are kind of three of the ones that come to my mind. We have a lot of clients from those countries. And so, and have had in years past also a lot of clients from those countries. Obviously, for our subcategory, China and India have this issue of not being current for like 10 years. So my question, really, I think I have two questions here. First of all, how did China and India get in that situation in the first place? And secondly, is that something that could happen to another country?
It could. It is not likely. The reason for the dates, the employment other worker dates for China and India, is because that date would not go beyond the regular third preference date. And in the case of India, the India third preference and India third preference other worker, as long as I can remember, it's been exactly the same date. With the China, the China other worker date has been often significantly. At one point, I think it was lagging by about 8 or 10 years. And the reason being, there was a significant amount of demand for China third preference other workers. And based on the annual limitations, there were not enough numbers to satisfy all that demand. And so that created a backlog. It's very interesting, though, as we started moving through some of those cases, we used to call them kind of phantom or ghost cases. Once their applicant's priority date was reached and they were potentially eligible for scheduling for an interview, or they could submit their documentation to become documentarily qualified, they never appeared or never submitted the documentation. So that's why in recent years, you saw a more rapid advancement of the China third preference other worker date. But again, now more of the applicants are starting to come forward. And part of the reason is when you have applicants with extremely old priority dates, often they're no longer interested. They've found a way to immigrate some other way. Whoever filed the petition for them has withdrawn it. They basically couldn't wait forever for Charlie to come and show up. So that's part of the reason for, particularly in the China, that date started moving forward more quickly.
Yeah, that's actually a really interesting piece of information. I was always curious because I was familiar with the unskilled category being pretty developed within China, but not really within India. But it makes sense that it's pulled back to those EB3, just regular EB3 numbers.
Well, and you bring up a good point. Whereas China did have employment third preference applicants, India did not have that many. So there really weren't, in the case of China with the other worker date, you could say people were being disadvantaged or held back potentially.
Yeah.
But in the instance of India, there just weren't that many India third preference other worker applicants. It was small. I'd have to go back and look at the data, but I'd say a couple hundred a year at most.
And so that backlog really comes from like the EB3 skilled and professional side, I guess.
Yeah, the third preference for India is, it's concentrated at third preference professionals, and whereas China third preference is split heavier on the skilled worker third preference, but a substantial amount of third preference other workers as well.
Got it. So even if, let's say, in theory, a particular country did kind of run into this problem with their priority dates being current, that would kind of happen gradually. It wouldn't be like all of a sudden there would be a really extended time period.
Correct. I don't foresee an issue with any other countries because there's just plenty of numbers for most other countries. And I will add one thing to the China issue. At one point, and I don't have access to the data now, but the overseas post, Guangzhou, was processing probably 30 to 50% of the other worker applicants. So if they still have a large number of applicants to be processed at Guangzhou, Guangzhou's basically been shut down for much of the last, since March of 2020. So they could have a large pool of applicants who are sitting there within the established China third preference other worker date that they have to kind of get through. And that may limit the China movement. It's one of those wait and see things.
Well, I think for our clients, this is all like pretty good news. We don't have any, Chinese or Indian clients unless they are eligible through cross chargeability with their spouse. But so I think that this is, probably a relief to a lot of people that are listening to this.
Yeah, I would, one thing I would suggest is if the immigration services, if they happen to publish their data in terms of their quote waiting list, how many people they have petitions for, if you look at if they put it up in a breakdown per country, you could look at that. The State Department, we would publish a report. Typically, it would come out in early December, mid-December, and it would show the immigrant visa waiting list listing applicants with petitions on file at the National Visa Center as of November 1st of each year. I know they'll be doing that this year. They'll have the National Visa Center run the report in about a week and a half. And in that report, it will break down the top countries in the various family and employment categories. So it will have a listing showing the top countries in the employment third preference other worker category, and you can take a look at that and see if there's any countries other than, say, China that are, have any concern in terms of the limit. But I just don't, other than India and China, I don't foresee a third preference date and other worker being applied to most countries.
Got it. Thank you for that. A lot of people here are like really wanting to know, like, is the visa bulletin going to be current, and when is it going to be current? And so I know that that's probably something that you don't want to speculate on and say, oh, I think it's going to be current in 2 months or whatever.
Current for the third preference
for
other
the third
worker?
preference for I think a lot of people in particular are especially concerned about the final action date chart numbers.
Right.
Because I guess that's ultimately when they would be able to actually get their green card approved or their visa approved.
Yeah.
And so right now it's June 2020 in BDV. At BDV, we're seeing a lot of clients, with priority dates prior to that and a lot of those are longstanding cases are finally getting adjudicated. Those people are very happy about the retrogression because it seems to be, pushing their cases to the front of the line. It's those people with priority dates after June 2020, and they're just trying to figure out like what the future holds, I guess. But I guess really no one's going to be able to know.
Right. And again, what they're going to try to do on a monthly basis is make available a certain amount of numbers under the annual limit. So I think that, the date has held for October and November. It's possible that when the December visa bulletin is posted, that you will see maybe a little bit of movement in the other worker category for most countries. But again, anybody that is listening and in the third preference other worker, the rest of world applicants, I can't speak to the Chinese and Indian, but if you have a priority date earlier than September 8th of 2022, I think that you should have an excellent chance of having your case finalized by September of 2023. And it's one other thing that is good news for your clients is based on the application filing dates. Like I said, that those allow people to file for adjustment of status. Immigration will take those cases and be working them if to the extent they can, and then they report them to the Department of State. So the Department of State will have them on file ready and know that, say, your client with alien number, the A number 123, they will know that that person is ready to go at the Washington district office or whoever's processing their case. And so that as soon as the date advances, they can get their green card, the final adjustment. The same thing overseas. Applicants who have submitted their required documentation to the National Visa Center, those cases are processed, and is they're documentarily complete, reported to the State Department on a monthly basis. And then as soon as the date advances, they can be scheduled for a final interview as well. So that is a very good thing. And by allowing those people to kind of get their cases in the processing queue, it allows the State Department to advance the date more regularly and not have volatility, because they can say, okay, we want to give out 900, we want to make use of 900 employment other worker visas during the month of December. They can go down and look at the amount of demand they have, and maybe they'll have to hold the date because they have more people than that within that date. Or if they say, okay, we've got the June 1st of 2020 date, and we want to give out 900 numbers, but we've only got 700 people with a priority date earlier than that, so we can move the date ahead to pull up 200 more people, with have later priority dates. So one thing that's very important for people is if you're notified by the National Visa Center to assemble and submit your documentation, it is extremely important to do that in a very timely manner. Because if you do so and that you have all the required documents, you will be reported to the Department of State. And as soon as a number gets available, you will be scheduled for an interview at the appropriate post.
I have a question about that. We got a comment here that's kind of relevant to that, which is recently we've seen visa issuance not really chronological. Like the applicant has a later DQ date, getting the visa after applicants with earlier DQ dates. Is that normal?
It would be, because say that you have so I don't confuse myself. Say that you have a January 1st, 2019 priority date, and I have a December of 2019 priority date. Well, the National Visa Center asked me to assemble and submit my documentation, and they also ask you to do the same. Well, I submitted my documentation right away, and you've been kind of dragging your feet for whatever reason. You had trouble finding the documents, getting whatever. Well, I submitted mine and was reported to the State Department. They would schedule me for an interview because I have everything ready to go, even though that my priority date is, months later than yours, but you're not ready to be interviewed. So that could be one reason. The same thing would hold true with the Immigration Service. If information needs to be submitted to them, it all is based on if everything that has been requested has been submitted and verified. So that's why I say, if you get request, submit your documentation as quickly as possible, because that you will not get scheduled for final action until they have everything.
Yeah, and I think that this is just a good example of how each case is different, really based on its own individual circumstances and factors. And so it's hard to kind of have a generalized answer with anything regarding immigration, I think, but definitely what we deal with here at BDV.
It also, the other thing is both immigration service and particularly overseas posts. Overseas posts have, as Chris could comment better than I, would have processing capacity. How many applicants they can be interviewing and working on a monthly basis. If the capacity, if the demand exceeds capacity, then a case may not be able to be scheduled, even though that it's within the final action date. And the same type of thing may be occurring at the Immigration Service if they have capacity issues at the, whoever is doing the final adjustment app, that may impact, the rate. So it could be different at different offices.
Thank you for that. The only other thing that really came to my mind right here is I had a comment up here that I wanted to pull up. Do you have any commentary on this guy's general concern, which is just certain embassies are taking a little bit longer to kind of reinitiate giving visa interviews? We're seeing, like in Nepal and Bangladesh, for example, we've had people that have been waiting like several years, and like we're finally starting to see some of those first applicants get their visa interviews. But people have definitely been concerned over the past several years with their process. So do you have any just ideas about this?
Well, as I mentioned, over the past, as overseas embassies and consulates have recovered from the essentially complete shutdown of visa processing, they've come back online at various capacity levels and at various times. Certain posts were able to start resuming normal processing, or some processing it earlier than others. So it's possible that Bangladesh, the embassy in Bangladesh, came online at a later period than other posts. And that would mean that they have a bigger, quote, waiting list of cases that were eligible that they need to process. And they'll try to process in chronological order of when the people would have normally been processed to the extent possible. The other thing is the overseas post may have limited capacity in terms of the officers, so they may have to prioritize the processing of certain types of visas. I can tell you that the processing of an immediate relative case would take priority over an employment case. So again, if they had, the embassy in Bangladesh had a huge immediate relative backlog, they may have to be devoting more resources to that versus the employment processing.
Thank you. Yeah, that's very good insight, I think, for sure. Christopher, do you have any other questions?
No, I just want to thank Charlie for his time. I've heard from like thousands of immigration attorneys and thousands of people in the immigration space would love this opportunity to talk to you. So I feel very grateful that we had this opportunity to chat a little bit, at least for the EB3 Unskilled. So thanks a lot, Charlie, for everything.
You're welcome. And what in regard to that Bangladesh question, I haven't looked in a long time, so I don't know if they still have it. But on the travel.state.gov website, they did have information at one point telling, how the various embassies and consulates were processing. And that may give you an insight, they're behind or they're back up to complete processing and what types of visas they are processing. So again, if you go to the travel.state.gov website, that information may still be posted on there in terms of, what's going on at a particular post.
Well, I can say that Bangladesh, I know Bangladesh itself has like 20, 30, 40,000 backlog of immigrant cases, right? And you only have like 6 officers. You can do the math on that, right?
Exactly.
Nepal is the same way. India is the same way. Unfortunately, there's some countries that have like the vast, like huge backlogs. And there's only like 5 or 6 or 7 officers that are going to be able to deal with that. And so unfortunately, Bangladesh is one of those countries, and Nepal is as well.
Yeah. And the National Visa Center was also posting information on the department's website in terms of, quote, waiting list or processing capacity, what was going on at the various embassies and consulates. And Chris, you made an excellent point just now. It's important for everybody to realize, and I don't want to sound like this is a company man giving a spiel, but I know that pre-COVID, most overseas embassies and consulates were already working at peak capacity. So the fact that they were at peak capacity then and then had to stop processing for an extended period of time, creating an additional backlog, that's going to cause strain on how fast they can do the recovery. And also, because of the COVID issues, the State Department probably was not able to train and have as many new classes to train as many new officers and have them ready to go out to overseas posts. So that normal consular training, which would be ongoing, was most likely negatively impacted by the COVID, meaning there may be fewer officers that were ready to go out to overseas posts to supplement what would normally be in a certain amount of attrition. Officers, sometimes decide to go into private practice or resign, go into another field. And so, there's staffing, the staff sometimes disappears or they may retire like I did. So, if you're not feeding that supply to keep everything up to speed, that's going to negatively impact things as well.
Well, hell, Charlie, maybe you and I should just go over to Bangladesh and Nepal right now. We'll hop on a plane right now and go do some visas. Let's just get them out, lock them out.
Well, I will tell you that years ago, when there was a huge non-immigrant visa backlog at various posts, there was an effort to send temporary help to those countries and the posts in them that had such a huge backlog of non-immigrant visa cases. That's a little bit more difficult to do maybe on the immigrant visa side, but again, it's something that's a possibility. Again, the other thing that I know that the State Department and the Immigration Service would love increased funding to allow them to hire additional staff to accommodate the increased workload. And one other thing I should mention is, like I said, the 2021 annual limit for the employment categories was 262,000. For 2022, it was, as I mentioned, the all-time high of 281,000. I am guessing that the limit for 2023 is going to be down to about 200,000. And for 2024, down to approximately 150,000. So those declining annual limits are going to make an impact on, the amount of visas that can be processed on an annual basis. So 2021 and 2022 were the golden years for the amount of applicants which were going to be able to be processed, barring, as you mentioned, Chris, congressional offices have in the past looked into recapturing visa numbers. That's a possible way to, make more numbers available. But again, if there were some type of recapture bill, it would be important for you and your constituents to lobby very hard for the employment other worker applicants to get a share of any recaptured numbers.
Mm-hmm. Yep.
So that's an important thing because, you've often got the big guns going after recapturing numbers for the employment first or second category. So you got to have people advocating for the third other workers as well.
Absolutely. We're working on it. Well, thank you so much for your time, Charlie. This was really insightful. Mitchell, do you have anything else?
No, thank you so much for joining us. I think this provides our clients a lot of confidence kind of into the process. And I mean, even us here at BDV, like we're constantly learning more about this and trying to like wrap our mind around how the retrogression is really, working. And so I think, yeah, it's very helpful to me, and I'm sure it's helpful to everyone that's watching this. So I definitely appreciate all of your time this afternoon.
It's been my pleasure. It's a very complex issue, and I used to tell people, unless you had to deal with it on a day-to-day basis, it was one of those clear as mud issues.
Definitely. I do have one actually quick question before we sign off here. During your time in the service, this particular visa category, was it kind of the smallest category, kind of most for in terms of immigrant visas?
Number use, it was probably so. There were periods of time when the number use in the other worker category was high, and then it seemed to drop off for a period of time. And you know, whether the demand dropped off because the petitions were not being processed by the service, or there was lower demand levels, it's hard to say. But the only other category, which the employment fourth preference and the employment fifth preference, they have relatively small annual limits as well. And in the earlier years, they had relatively low number use, but for probably the last 10 years or so, their number use has been high. Whereas the employment third preference, other worker, not so much. And part of that is evidenced by the fact that the third preference, other worker category had remained current for so long. That kind of means that there was not demand to use all 10,000 numbers. So again, whether that was a lack of demand or just a lack of demand because petitions were not being processed in a timely manner.
Cool. Interesting. Well, thank you so much, Charlie. We really appreciate your time, and hopefully maybe we can have you online again sometime.
Okay, it'd be my pleasure. I love talking to people.
Perfect.
Hopefully I didn't ramble too much.
Nope, it was perfect.
No, we loved it. Yeah.
Thank you so much, sir.
Okay, take care.
All right. Thank you. Take care.
Bye.